I started doing death penalty work almost a decade ago. I was really just doing patent litigation. That's what I do for my practice, and wanted to expand, one, my skill set, and also I wanted to work in an area that I found interesting where I could help the community. And took on a case down in Virginia, and we ended up at that firm setting up a death penalty program where we had 5 cases within the first year, all of them on direct appeal at the Virginia Supreme Court. When I was leaving that firm, I was recruited to join another firm and do patent litigation, and the first week, probably even before I started, Jack's case was taken into the firm. They had, out of 3,000 lawyers worldwide, they had 0 attorneys who had any capital experience. The case was kind of a pet project of one of the partners who I worked with, who was the number 2 guy at the firm. It's a Magic Circle, big firm, and he asked if I would work on it. We looked at the case. Jack was, he was convicted in the 70s, right after they reinstituted the death penalty. He was the second person to get the death penalty under the new regime, and he sat on death row for a long time. So we were coming in very, very late, and we had very few options. He had already gone through all his direct appeals. He was sitting, waiting for his final rejection from the 11th Circuit before I joined, and then we were filing his Supreme Court case. So when I came in, having worked in the death penalty arena, I started talking to other people about what we could do, and we all came to the conclusion that the only option we really had was to file a civil lawsuit against the state of Georgia for a violation of the 8th Amendment. And what we were arguing, and what we did argue in the case, was that their use of lethal injection was a violation of his fundamental constitutional rights. The problem was that at that time, which has changed some, is that everyone who was filing these cases was treated as they were only filing them to delay their client's execution. So Jack, we had talked about when we were going to file our Supreme Court brief to argue his innocence and argue the merits of his case. And some of the attorneys wanted to file it early because they thought, well, if we file it early, the Supreme Court will know we were serious. It was one of the, if we had done that, we would have never argued any of these cases. So we made it, we filed it on the last day we could. It ended up that we made it to the October term, so he didn't get dismissed. His case did not get dismissed in July. They waited until October, but it gave us time to develop our claims on the 8th Amendment challenge. And so what we found in doing this case, and just one other thing I want to mention, this is a civil lawsuit. This is not a criminal case. When we got into filing the lethal injection challenge, we're now in civil court. We were in front of a judge down in the Northern District of Georgia. We filed the case. We made allegations that were based on what we knew. A lot of it, the state was very open about it. Georgia was different than some of the other states, where they were actually open about their method of execution. So what we did, we filed their claim, and basically what we said was, by them using this method of execution, that it was a violation of his constitutional rights. They were using the state, they were state actors, people who worked for the state, and therefore we were allowed to bring this under 1983. And 1983 claims, as you can see, it authorizes a civil action against people who work for the state for depriving someone of their constitutional rights. And so that was our argument. And what we found was really horrifying, and as you guys have seen over the years since that happened, is that there are issues with method of execution. And if you go back to when, in the 80s, when they started implementing this method, the person who implemented it on the fly just said, you know what, if you mix these 3 drugs, this person will die. They never did any studies on it. They didn't test animals. They didn't test, of course they didn't test it on humans. They just decided, let's use these 3 drugs, and what it'll intend to do, let me skip, is first they gave sodium pentothal. And what the sodium pentothal will do is it will go in and it will knock someone unconscious. That's the idea. The problem with sodium pentothal, and most of my practice is doing pharmaceutical patent litigation. So this was really interesting to me. But if it will crystallize in the tubes, if at different temperatures, and so if it crystallizes, the sodium pentothal will actually block the tubes from letting the other drugs get in, and may not allow it to work fully effectively. So when you put sodium pentothal into the body too, it goes through the brain, the membrane in the brain. So you're actually circulating through the human system, and then it's got to anesthetize the person into the brain. So you don't know, you aren't sure that it's actually getting to the person. And Georgia did nothing to confirm this. So all they did was they had, and I'll skip ahead so you can see just about how the chamber is. And so you would have this curtain here. You would have, they had an actual phlebotomist come in and put in they had two lines, one in each arm, into his arms so that they could inject the drugs into the system. Jack's holding cell, the days before he would be executed, was right here. And then there was a guard who sat there, 24 hours a day during this time. So Jack would be brought in. They would strap him down into the lethal injection into the table. The guards would stand behind a glass mirror, and the I don't know how they put it as like the esteemed people, the Attorney General, other individuals would be waiting in there, and then and then there were witnesses here. But so what would happen is the nurse would come in, and the phlebotomist, and put in the veins. Now that's the first part. So you're having someone who was trained, which is also different from a lot of the states because most medical professionals want nothing to do with an execution. What she did, she actually put in the veins. So that was a positive that Georgia had over some other states. The problem is if it doesn't work, they use something called a cut-down procedure. She's not trained to have a cut-down procedure. Virginia doesn't use phlebotomists. They use just prison guards. And a cut-down procedure goes in through the groin, and you cut into the artery in the leg. This is a really complicated procedure, and most medical professionals don't use it. So you have a guy who's a medical corrections officer. You're asking him to go in and perform a complicated medical procedure that a phlebotomist couldn't do. So then she would go behind, and they would start pumping in the drugs. And there were two corrections officers who actually got paid more money to pull the plungers. So they would want to be doing this. And one would have just non-drug in it, and one would have drug because one of the things about our society that we've had since we started doing executions is the guards don't want to know who actually pulled the plunger that killed the guy. So they had two individuals, and what they would do is it was a 7-line flush. They would first flush the line, then they would put in sodium pentothal, then they would put the drug in, or another saline solution to clear out the line. And then they use pancurium bromide, which is allowed to paralyze the inmate. So now you've given sodium pentothal, was supposed to knock him out, and then you give something that's a paralytic. That's totally unnecessary. Now, if the inmate is not anesthetized initially, he's feeling everything that the pancurionium bromide does to his body, which is making him paralyzed and making him not be able to breathe. Their chest cavity can't open up at all. And we actually, one of the things that we did, we had filed a motion in state court in Georgia to allow our inmate to be heard by the Board of Pardons and Paroles. And what they argued was two things that they wanted to get this over with because of the victims of the family. And what we argued to them on this issue was we didn't think our client needed this at all. And the reason we didn't believe it was we didn't want him to be paralyzed. We wanted to know if he was feeling pain or if if there was a problem with it so they could stop the procedure. But they said it was to be dignified to him so that he wouldn't be showing shaking, showing anything to these people who were watching his execution. When I argued this at the 11th Circuit, that was what they argued too. It was a really strange argument, and we had a 3-judge panel. One of them was a former Attorney General for the state of Alabama, who actually told the state that that was the most ridiculous claim he had ever heard. So then the third drug goes in, and potassium chloride causes a massive heart attack. So now you've got an inmate they've given sodium pentothal, which may or may not have worked. They've given him pancuronium bromide, which is paralyzing him, so now he can't tell anyone there's an issue, if there is an issue, and then you're going to pump in a drug that's going to cause massive heart attack. Now, during none of these steps, after the nurse puts in the drug into the vein, or excuse me, the line into the vein, is anyone checking our inmate to make sure that he's actually been anesthetized? And so this was the chamber. Now, there's no one, because the guards are behind. They're not looking at the inmate. They're watching their clocks, counting down. This is dimly lit. They're dimly lit. So when we stood behind there, because part of what we wanted to do was inspect the chamber. So we did an inspection of the chamber. You can't see at an angle what he's doing. So the only person who could have seen anything, and he would have had to do this before they put in the pancuronium bromide, is our client would have had to do something at that point to give an indication that it wasn't working. But once they gave that second drug, which is faster acting than sodium pentothal, our client had no one went out there and checked him. He couldn't do anything because he's paralyzed. So we believed, and we went to the court and argued that this was an unacceptable risk, that our client was going to suffer cruel and unusual punishment. So fortunately for us, we got to develop this claim because at the time there was Bays versus Reese, which our Don Verley, who is now our Solicitor General, argued from Skadden Arps. So we got to stay, and we got to develop all of this. We got to take the deposition of the warden. We got to take the deposition of the individuals who were involved. We got to take the deposition of a person, of Dr. Dershowitz, who's in Massachusetts, and who consults with almost every state now on lethal injections, and has actually provided protocols to them to tell them how to do it. And as you've seen, we saw in Arizona, he's doing a bang-up job giving them indications as what drugs they should use. One of the other things that I found fascinating about doing this case was that under the AVMA, the American Veterinary Members Association, or it's AVMA, you couldn't use this protocol to kill a dog. So if you go in and you have your dog put down and they did this, they'd be violating their veterinary medical ethics. So we've seen, as we've seen over the years, and when we argued, before we went to the 11th Circuit, we argued at the summary judgment stage. I told the judge at that time, which is sad that it's come true, is that this is not the end of this. That we are going to see more issues coming forward. We're going to see more people in this, and the arguments that we made were right. We said that you're using untrained individuals to do these procedures. You're storing these drugs in places that they shouldn't be stored, because as anyone takes, drugs expire, they need to be kept at different temperatures. And if you don't do that, they're not going to work as well. And none of that was happening. And it's still not happening. And that's why we're seeing these issues like what we saw in Arizona recently, we've seen in Ohio. And for whatever reason, the states don't seem to really care about this at all. The only state who hasn't had issues, and the only thing that we can really come up with as to why we haven't seen any issues yet, is Texas. And that's because they go through, those people are trained because they do execute a lot of people every year. They're the vast majority. I think now it's over 2/3 of all executions in the United States every year are done down in Texas. So, these are the claims that we made. I think over the time that it's borne out that we were right. And, I don't think the Supreme Court is going to take this again. They dealt with it. They said They've given standards that haven't really impacted this at all. And we're not seeing any changes in the protocols, except, now what they're doing is trying different drugs that they think will lessen that will accomplish their same goal, but they're untested, and no one would allow any other drug. As someone who does patent litigation and sees clinical trials, you can't bring a drug to do anything unless you have significant testing on it, except the states are constantly doing this. They've changed their protocols. They jump around. When someone makes a claim, they change it. But the only expert that they've had on this is an anesthetist who doesn't really seem to know what he's doing, because if he did, we wouldn't be having these issues. And when we deposed him in this case, he doesn't, of course, tell his hospital that he does this. He doesn't tell his patients. He doesn't advertise this in any way. And he rejected any claim that he was violating the AMA rules and the guidelines, because he was saying, I'm not telling them how to execute someone. Except after we did discovery, of course, he's giving them guidance. He's telling them what they should do. He's trying to give them what drugs they should use and what order they should do them. But it doesn't take the place of someone who's trained to do this. So at this, so now what we're seeing is just basically, this has been a 10-year process almost of when these started. We're seeing states trying to change the procedures. They're trying to do them without public scrutiny. And we're seeing that inmates and individuals are being executed by untrained people without proper guidance and testing on what they should be, on what drugs they should be doing. And they're using protocols that they couldn't even use if they were putting down an animal. So it's a sad state of affairs, I think, in the United States that we're allowing this to happen. And I don't think it's going to change much. I know, when I've given these talks or talked with people before, everyone wants to, do you think Jack, they always want to ask about the substantive case and what Jack did or didn't do. Jack was alleged to have killed his wife. It was 30 years ago. Whatever that person was who may or may not have done that crime, because I don't honestly have no opinion on his guilt or innocence. That person was someone who was different than the person that I got to know over the year and a half that I represented him. And when Jack was executed, one of the reporters from the Savannah Times, this happened in Savannah, Georgia, was nice enough to call me, because he was at the execution, and told me that the person that he knew, who was angry and violent and was just this really angry person in the early 1970s, was a very different person than the person that he saw when he was executed. And so people change. I don't know if, who Jack was in 1974, 75 when this occurred. But the person that I got to know wasn't that same person. And so, in my practice, I don't usually take cases that have claims of innocence, because there's a lot of lawyers who will take those cases. I usually do cases that have pretty straightforward guilt issues, but they have a very significant issue in mitigation, childhood, some pretty bad childhood traumas, things of that nature. So working with Jack honestly was an honor. He was a pretty special person in my life, impacted me in ways that I would never have guessed someone could have, and representing him was one of the highlights of my career. So I'm happy to take any questions on this case, on representing Jack, or just doing this work in general. I know there's a lot of stuff going on in the news about this. I don't know what's going on with the Arizona case. I'm not sure what they're doing there. I know that there's some wrongful death suits that may be coming, or may be coming is what I've seen in the news. But I'm not sure where that stands. But Arizona is, from what we've seen, is they are going to go forward with the same method that they used to execute. I know a lot about California. I don't know what happened with his case, because the case that they were representing a client on was further north, and it was with a Judge Fogel, and that was what really got started the lethal injection challenge that happened in the United States. Don Verrilli and Ginger Anders, who were at Skadden, Don, as I said, is now Solicitor General under Obama. They did a fantastic job on the case. They haven't committed an execution in California since his case. California is a little different than Georgia in that in California they had a gas chamber that they converted into a lethal injection chamber. And what Judge Fogel required them to do was build a new facility. And under Schwarzenegger, you didn't need to have approval from their state Senate and state House if you kept it under $1 million. So what he did was he tried to build it and said with appropriations and do it for much less than that. Right, like I think we put it in for like $999,999. I mean, totally flouting the rules, which got stopped. So California isn't going anywhere for a long time, and I just don't see how their politics going forward that they're going to be able to do any executions. And I don't think there's just a public outcry to have executions in California. One of the things that I think is really interesting about the death penalty in general is just there's no real discussion about it. There's discussions there, very emotional discussions about it, but there's a lot that goes on in the death penalty arena that just no one discusses. Because it's way more expensive to execute someone than to have someone on life without parole. Juries are not allowed to be told that if you have a life without. Yeah, it's much more expensive to execute someone than to put someone in prison for life without parole. And the reason is because you have a right to counsel when you're going to execute someone. And you don't have a right to counsel always when you're just going to have them live in prison forever. So that's one thing. The other is that juries aren't told what life without parole in the United States actually means life without parole. If you get life without parole, you're going to die at some point in prison. Either, you're going to live your natural life. So if you're when someone's making a decision if you're going to get life without parole or be executed, both are death sentences. One is just going to last. You're going to live much longer in prison. Also, there's a lot of, I was on the board of an organization, EJUSA. It's a fantastic organization, and what it does is it really looks at holistically at the death penalty and just our criminal justice system. And one of the things that happens is once you get that execution, that death sentence, the victims' families are just left with nothing. They get no support from the state. They're left to deal with the aftermath of this. And what EJUSA does, one of the things that they really work hard at, and one of the platform issues is getting funding for victims families and for those people. What we saw in Colorado when they got rid of the death penalty, the funding that they saved from having to execute people was they gave it to victims organizations, family organizations, and other areas where they felt that it would actually help the overall criminal justice system. So, there are ways that we can look at this different than whether we should execute someone or not. It's looking at the criminal justice system as a whole. I do think the states, they're trying. But you're limited in the capacity on what you're doing. If we actually look, Deborah Deno, who's at Fordham, has done a study on executions and over time. And when the Bays case was coming, she believes that the least painful way of executing someone is by shooting. And so one of the things that when they argued this at the Bays versus Reese, that Judge Scalia asked about that. But what we also see from the states is they care about, they may say that they are trying to make it humane, and you can argue that. But I think it's something different is that they're more worried about public perception of execution than making it more humane. I mean, for them, it's much better to use pancuronium bromide, which is going to paralyze the inmate, where no one's going to see the shaking and him dying, than having a public hanging or having a firing squad, kill someone. So I think there's a dual purpose. It makes it much less controversial to people if you believe that when someone's being executed that they're not feeling any pain, and that it's not, that they're not. It's not this, someone getting their head blown off or being hung, and they just peacefully go to sleep. Than the other. I will not. I didn't go to Jack's execution.
You don't
No, this was, I didn't go to Alderman. You mean Jack Alderman's? Yeah, Lockett's a different.
Right, no, I'm asking you about Clayton Lockett. I thought, because the students might have heard about.
Oh, no, I mean, Jack Alderman, when I didn't represent Clayton Lockett.
Didn't
No. But Alderman, I didn't go to his execution. We had a talk about it. I talked to other people. I didn't know if I could continue to do this work if I was seeing my client be executed, and it was more important for me to continue to do death penalty work. I got to see. No. I think a lot of you're dealing with a lot very damaged individuals who commit these kind of crimes. And so, like the client I'm representing now, we formed a pretty close bond, partly because I recognize, working with Jack, over that period of time, I was down in Georgia at least once a week, spending time with him. And so you get to know this person as a human being rather than just, an inmate or your client. And I think that it's really important when you're doing this work to really understand your client and know who they are and build their trust. And not only has it helped me in my death penalty practice, it's actually helped me a lot in my regular practice, my patent litigation practice, because, the clients that I deal with, even though these issues are way different than when you're dealing with life or death, it's still really important to them. And so caring about your client and working with your client and making sure that you have their trust is invaluable. And I think that's really in anything you do. And Jack really had a huge impact on me. He used to send letters. My son would draw pictures for him. It was a really good relationship. I met Jack in 2007. So it was almost.
Incarcerated for a very long time.
Yeah, he was at the time he was the longest serving inmate in the country. So Georgia wasn't. At least they weren't efficient in executing.
Thank goodness.
Yeah. The clients that I represent, there have been facts and circumstances of the case that make it more difficult to represent them. And children, whenever you involve kids in a case, it's much more emotional. But I would like to think that I would represent them, just as I represent anybody else, because, none of my clients that I've represented who have had strong guilt cases, I'm sitting there thinking, wow, this is a really great person. They still made a mistake. But I guess how I look at it too, when you're representing, that's just a great question. I really have never thought about it. But yeah, when you're representing them, if you think about it, the worst moment in your entire life, the worst day, the worst thing that you ever did, and if you let society judge you on just that sliver, that would be a horrible thing. So when we're representing these clients, what we try and do is kind of take a more holistic view. We look at their backgrounds, we look at what they went through, we look at their lifestyle and what happened. This fly is very annoying. So we try to present to in our case, and I don't do cases they're always on appeal or habeas. So I'm dealing with it after another lawyer has done a lot of work on the case. So what they try and do, and what these public defenders do, or people who work on death penalty cases, 100% of the time, they are really trying to get a full picture of what the individual went through. And I think and I believe that I would represent a client who committed a crime against a child the same that I would, represent as anyone else. I wouldn't have my son, honestly, wouldn't have my kids writing them letters or doing something like that, because it's a different circumstance. But for me as a lawyer, my job when I represent anyone is to represent their interests 100%, and I think I would do that. No, you're involved with it. I would probably build a relationship with that. I would, not with my kids wouldn't, but I would build a relationship with that individual like I can honestly say none of the people I've represented, for those people who I know there's no claim of innocence. Jack had a claim of innocence. And for those people, I didn't treat them any different than any other client that I have. I knew Jack's dad, who was pretty old, but that was the only family that he had. So, there are we do it when we're doing the mitigation investigation, or you're talking to people. You do meet their families. The first case I ever did, it was a post-conviction case where I was doing the direct appeal at the Virginia Supreme Court. But before we got there, we had to develop part of the record. And I would go into court, and the victim's family would be there. And they were of course, very hostile. They didn't like that this lawyer from New York was coming down to a small place in Virginia. And they were very hostile. But then, it was about 6 months later when we were at the direct appeal and I was arguing at the court, I saw the victim's parents, her parents, and they didn't know where to go. There was no one from the state helping them. They just ignored them. So me and my mitigation specialist walked up to them, introduced ourselves. We knew that we know that they're going through a hard time. We're very sad for them. They went through a very difficult time, whether our client did it or not, because he had a claim of innocence that we developed. But that family, they were very grateful. They didn't know, going back to like the Victims Family Services, they were just left to come down to the Virginia Supreme Court and watch this argument because we want to let the court know that the victim's family's here. But they got no services, they got no support, they got no counseling, they got no funds to bury their daughter. They got nothing. And so that was really, I thought, was really interesting, or very sad. But most of all of my clients, I've met their families at some level. Some of them don't want to be involved at all, so you can't. But you always try to reach out. How many clients? Right now, Jack is the only person who's been executed. So everyone else is on direct appeal or on habeas. But I got in much earlier in the case. Jack was. When we filed this lethal injection, we didn't. We were shocked that it lasted as long. We were really shocked at how successful it was. Am I personally in favor of the death penalty? Let me give you the legal answer, and then I'll give you my personal answer. Let me give you I think the death penalty we should not in the United States have the death penalty personally. Absolutely. No, unequivocally, especially how we have it. The answer on if I was doing a constitutional analysis legally, I think that the only way, and when Connecticut was getting rid of the death penalty, one of the state senators I talked to a lot about it, Terry Gerentana. And what she said, when I thought was a really great analysis of it, she said, it's very hard on the victims' families to have these long, drawn-out, where it takes 10, 15, 20 years before someone's executed. She goes, the only way that you can shorten the time is shorten the amount of appeals. She goes, but humans are fallible, and if we shorten the amount of appeals, the risk is inherent that we're going to execute someone innocent. So in her opinion, and I agree with this, that it would be very difficult to build a system, and not an individual case, but a system where you are not going to execute someone who's innocent. It's just not going to happen. I think in the last, from my memory, in the last 10 years, there's been 2 women executed, and in the last 10 years, there's been a lot more men. I don't know what it is. When George Bush was president and do you remember the Carla Faye Tucker case down in Texas? Right, so Carla Faye Tucker had a pretty heinous crime, became very religious in prison. Every religious group in the country was in favor of commuting her sentence. I think the Indigo Girls have a song. They talk about her too. So she, George Bush, he executed everyone. If he could have executed half his state, he would have. He wasn't swayed by it, and I think he was president at the time. I do think there are some states that are, if there's someone who's ready to that should be executed, and they believe there's executed. There's also a disproportionate amount of men who commit violent crimes than women. There just is. So I think you'd have to look at the ratios of the women who commit violent crimes who are executed versus the men who commit violent crimes. I think in this country, though, it's a racial issue. So if you look at the statistics, your chance of getting executed, it really doesn't have so much to do on your race. I mean, when you get to the trial stage, it does somewhat. It's the race of the victim, and I think that is another major problem with our society in general, and with the death penalty. So it's the disparities that we have there are just shocking. And if, you know, I don't know if you guys have seen this, but there was a recent innocent case. Guy was 30 years, just let out of prison. That case, when it went up to the Supreme Court and they got rid of, and they said, no, we're denying it, Scalia said, this person who was just found innocent is the reason we have the death penalty. So it's a system that doesn't work, and you can't have a system, I think, for the death penalty that is, you know, going to execute innocent people.
If someone killed your son just for the hell of it, how would you feel about that?
I'd want them in prison for the rest of their life. I'm happy if they will let me in a room with them and I'm the person who's going to kill them, fine. But as a state, I mean, I see what it does to the victims' families. You know, it wouldn't be just that one time of having to go through the grieving of losing my son, of having to sit through a trial where I have to hear the gory details. It's going to be a 20-year odyssey of every 3 to 6 months of me hearing about it. I would much rather that person rot in prison with life without parole. And that is, you know, I think that's better than Dukakis's answer in 1984, 88, right? So, well, I don't know if I remember these random things. Michael Dukakis, I don't know if you guys have seen it, if you Google it, it's on YouTube. He was asked if his wife was brutally raped and murdered, whether he would believe, whether he was for the death penalty or not. And he gave this very professorial, non-emotional answer, which of course, like it's an emotional issue. You want like, I understand that emotional issue of retribution, but our government is not supposed to make decisions emotionally. We just shouldn't. We as a collective or an individual, of course we make decisions emotionally, but our state and our government shouldn't. I just don't think we should. I've had 2 clients who have wanted, I mean, Jack, when we were at the end and we were going to the Board of Pardons and Paroles to try to get him commuted, he said unequivocally, and he, you know, he told everyone, he said, if I have 2 choices, either you execute me today or you let me out. I'm not spending I'm too tired, I can't do it. So, I mean, there are individuals who decide that that's what they want. It's when you're a lawyer, when you're representing someone like that, I have another client who we've been going through that for the last year. It's a very difficult thing for you on what you do. How do you advocate for them? Do you stop the appeals, or do you not? And I mean, I don't have the right answer on it. I don't know what I would do in that situation. There are, a lot of these states, it's 23 hours a day lockdown in a very small cell. When they are let out, it's in a cage. So we have a right. We have an obligation to represent them. You have to look at the individual. You have to look at their state of mind. You have to look at their mental health issue. There's a lot of mental health issues with people who are locked up in solitary confinement 23 hours a day. I know that's surprising to everyone, but there was a case in Arizona. Right. There was a guy in Arizona who they smuggled in some drugs to kill himself. They recuperated him and then they executed him. There was a case in Ohio 2 years ago where the person had waived appeals, and his lawyer said, I tried to convince him, and this is what he wants.